Welcome to K&L Gates' Working Wise podcast series. My name is Saman Rejali, and I'm an associate in the Los Angeles office of the firm's Labor, Employment, and Workplace Safety practice area. In this podcast, I'll discuss tips and common mistakes to avoid for California employers. California is a notoriously employee-friendly state and can present significant challenges for any employer, particularly employers coming in from other states who are accustomed to what are typically more lax labor and employment laws. We'll be covering a variety of topics that often cause trouble for California employers in today's podcast. Let's first discuss California's Labor Code Section 203, which requires that an employee's final wages be paid upon termination or within 72 hours of resignation if the employee quits with no notice. Failure to comply with this provision will result in the imposition of waiting time penalties at the employee's daily rate of pay for up to 30 days or until the employee's final wages are paid. It's important to remember that final wages includes any accrued but unused vacation time. Any commissions that have been earned and can be calculated must also be paid out upon termination. Another California law that often causes out-of-state employers to trip up is California's policy against forfeiture of vacation time. Under California law, employers don't have an obligation to provide employees with vacation time, but if they choose to do so, there are several requirements that they need to be aware of. First, earned vacation time is considered wages under California law, must roll over from year to year, and cannot be forfeited for any reason, even upon termination, regardless of the reason for termination. An employer may place a reasonable cap on vacation accrual, typically at least 1.5 times the yearly vacation allowance, such that employees stop accruing vacation time once they hit the cap. As I previously mentioned, accrued but unused vacation time must be paid out along with the employee's final wages upon termination. Next, we move to an area that has resulted in significant litigation over the last decade, California's Fair Employment and Housing Act, commonly referred to as the FEHA. Specifically, its requirements regarding engaging in the interactive process in accommodating disabled employees. The FEHA applies to public and private employers with 5 or more employees and prohibits discrimination and harassment based on a protected category against an employee or applicant. The FEHA also prescribes certain requirements related to the handling of disabled employees, including a duty to engage in an interactive process with the employee with the goal of establishing a reasonable accommodation that would enable the employee to perform the essential duties of their position. Claims for failure to accommodate and engage in the interactive process differ from other claims under the FEHA in one significant way. There is no requirement that the plaintiff prove that animus motivated the employer's actions. These claims are purely mechanical, and as such, administrative errors resulting in a failure to recognize the need to engage in the interactive process can result in significant liability. It's critical that employers who are on notice that an employee may be disabled or have a medical condition take steps to engage in the interactive process to determine whether the employee requires a reasonable accommodation. This can be an informal process, but should be documented internally so the company has records that it took necessary steps to engage with the employee should litigation ensue. From a human standpoint, employees will often have a more favorable view of their employer and feel less inclined to sue where a reasonable accommodation isn't possible if they feel the employer paid adequate attention to them and didn't let them slip through the cracks. Another issue that presents problems for employers in California is misclassification of employees as independent contractors. There's a misconception among many employers that the designation of independent contractor is one that can be agreed upon by contract. That is, if an offer letter states that a worker is an independent contractor and is countersigned by the worker, that makes them an independent contractor. Whether someone is an independent contractor is a legal determination, and it cannot be altered by private contract, and the potential liabilities and penalties for misclassifying someone as an independent contractor are significant. There are a number of factors to be considered when trying to determine whether a worker is properly classified as an independent contractor, but the key touchstones are the degree of control the hiring entity has over the work and the manner in which it's done, whether the worker is providing a service that is distinct from the hiring entity's ordinary business, and whether the worker is customarily engaged in an independently established trade, occupation, or business that is of the same nature as the work being performed, such that the worker would ordinarily be retained simultaneously by multiple entities in connection with his or her trade. These are the 3 elements that were set forth by the California Supreme Court in its decision in Dynamex Operations West Incorporated versus Superior Court, which is now the standard for independent contractor classifications in the transportation industry. The court's decision is likely indicative of the direction in which California jurisprudence is heading on the independent contractor issue, but the economic realities test set forth in S.G. Borrello and Sons Incorporated versus Department of Industrial Relations still applies in many scenarios. The most significant factor to be considered under the economic realities test is whether the hiring entity has the right to control the worker as to the work done and the manner and means by which it is performed. But the following factors are also considered. 1. Whether the person performing services is engaged in an occupation or business distinct from that of the principal. 2. Whether or not the work is part of the regular business of the principal or alleged employer. 3. Whether the principal or the worker supplies the instrumentalities, tools, and the place for the person doing the work. 4. The alleged employee's investment in the equipment or materials required by his or her task or his or her employment of helpers. 5. Whether the service rendered requires a special skill. 6. The kind of occupation, with reference to whether, in the locality, the work is usually done under the direction of the principal or by a specialist without supervision. 7. The alleged employee's opportunity for profit or loss depending on his or her managerial skill. 8. The length of time for which the services are to be performed. 9. The degree of permanence of the working relationship. And 10. The method of payment, whether by time or by the job. Whether or not the parties believe they are creating an employer-employee relationship may have some bearing on the question, but is not determinative since this is a question of law based on objective tests. An independent contractor should operate like any other vendor, like your plumber or your electrician. If you are treating your independent contractor like an employee, giving them business cards, a company email address, and are generally controlling their work, they cannot be classified as an independent contractor, and there is no agreement or reflection of assent between the parties that could render them one. Our next topic is arbitration agreements. Arbitration agreements can be of great value to employers, particularly since the U.S. Supreme Court's decision in Epic Systems Corporation versus Lewis validating the use of class action waivers in employment arbitration agreements. But it's important for employers to go into employment arbitration with their eyes open. Though arbitrations can save employers from the threat of a runaway jury verdict and can certainly provide an enormous benefit when it comes to preventing the filing of class actions, they are often much more costly than litigation before a court of law. Arbitrators have no incentive to keep their hours and fees down and will rarely intervene to limit the scope of discovery for fear of getting reversed for failure to allow all pertinent and material evidence. This inevitably leads to both excessive arbitrators' fees and attorneys' fees, as plaintiffs' attorneys have much more freedom to conduct fishing expeditions in discovery. The scope of discovery then results in arbitrations that last 2 or 3 times as long as a trial would, because arbitrators are likewise unlikely to limit the introduction of witnesses and evidence at the arbitration. Though the final outcome can still be financially advantageous, particularly if a class action is avoided, employers are often shocked at the cost of the arbitration and the amount that ends up being expended on fees. If you've decided that you want to put arbitration agreements in place for your employees, the next step is to ensure that your agreement is enforceable under California law. In 2000, the California Supreme Court set forth criterion for determining the enforceability of arbitration agreements required as a condition of employment. The agreement must provide for a neutral arbitrator, adequate discovery, such as access to documents and the right to take depositions, allow the employee all remedies that would be available in a court of law, require the arbitrator to issue a written award, and for the employer to pay the fees and costs of arbitration, not including attorney's fees. Arbitration agreements must also comply with principles of conscionability. For example, an arbitration agreement that isn't bilateral, meaning one that requires the employee to arbitrate any dispute with the employer, but allows the employer to pursue disputes in court, would not be enforceable. It's important to note that while class action waivers are permitted pursuant to the decision in Epic Systems, claims under California's Private Attorneys General Act, or PAGA, are exempt from arbitration. The final issue we're going to discuss is the enforceability of restrictive covenants. Covenants not to compete are not enforceable under California law pursuant to Business and Professions Code Section 16600. There's a narrow exception that applies in the context of the sale of all or substantially all of a business or the dissolution of a partnership, but outside of that context, competition cannot be prevented in California. The most restrictive covenants that can be enforced are non-solicitation covenants. Until recently, narrowly tailored employee non-solicitation clauses were generally enforced in California, while no higher provisions have been struck down by California courts. However, recent decisions applying California law, including the California Court of Appeals decision in AMN Healthcare, Inc. versus Aya Healthcare, LLC, and the Northern District of California's decision in Barker versus Insight Global, LLC, have suggested that the tide is turning against employee non-solicitation clauses. With respect to solicitation of customers, non-solicitation of customer agreements can only be enforced in connection with the use of confidential information. Essentially, non-solicitation of customer agreements are really agreements for the protection of trade secrets, but written so that they are directed specifically towards the use of trade secrets to solicit customers. Employers should be careful when drafting restrictive covenants in California because California does not allow blue penciling and will not allow an employer to fall back on less restrictive language if a restrictive covenant is deemed unenforceable. In addition, including unenforceable clauses in an employment agreement can be deemed an unfair business practice under Business and Professions Code Section 17200, subjecting an employer to additional penalties. We hope you enjoyed this episode of K&L Gates' Working Wise podcast series. More episodes in our series can be found at klgateshub.com, and you can learn more about our labor, employment, and workplace safety practice on our main website, klgates.com. Thank you for joining us.